We're live on YouTube, on the YouTubes. Um,
Yes.
from what I understand, we may have had do they call it a lockdown when you don't let any of your jailed individuals out of when we don't let any of your jailed individuals come to court so that they can assert their right to speedy trial?
I believe so. Yes, I believe it. I believe it's they're saying when they tell us that the jail's on lockdown. I believe lockdown is the actual term they're using right now.
So when they were always locked down, what was that?
Jail.
That was just jail.
Now they're on super jail.
I'm
What
just
year,
shocked.
what year do you think it will be when they determine that jail is really not a good way to deal with people's misbehavior with respect to the
You
law?
know, Ray,
Because
it's funny you say this.
it's gotta be soon, because it's the stupidest thing. It's like a timeout. Hey, man, you're getting a timeout.
I was thinking earlier today, and Pat, maybe you could answer this question, having been at some point inside the belly of the beast. What percentage of prosecutors in history ever did work on the outside defending people, did really serious stuff where they had to help people looking at a lot of time in jail? And what percent of those people ever went on to prosecute? Like, it seems there's a pretty serious problem that the people who are making policy decisions to put people in jail for a long time have never experienced what the other end of that is like, and it's never been humanized, and they've never had to. And what's crazy, what made me think of this is I one time in my life convinced the prosecutor to go into lockup and talk to somebody because he accused me of having a story for this person and having a story for every single person. And it caused me to think that as a defense attorney, the reason we have a story for every person is because every person has a story, right? But when you're a prosecutor, you're just looking at numbers and stuff like that, and you never see these stories.
And as far as people going from defending real life people whose lives are going to be, torn upside down. I'm going to lose my job. I'm going to lose my house. I'm going to lose everything I have if I have to go to do, this 30-day stretch. I don't know anybody who's done that. I don't know anybody who's defended somebody like that, a real person whose life is about to be completely trash canned, and then went and prosecuted.
Right.
I know a huge number of people who prosecuted and then went to, defend. And that was one of the most surprising things. I knew, the majority of the people that I prosecuted when I was with the state's attorney were normal people who had a bad night. You could see that. What I didn't know is that 96 or 98% of the people I represent are normal people who had a bad night.
That's the thing. We have every one of these people, you come up with a story because they have a story because they're humans, right? I mean, it's like, we're not making this stuff up. We're usually repeating or spinning what we heard. But like this guy today, I'm trying to continue his case. He just started a job in February. He makes $14 an hour. He can't get time off because he's on his probationary period. I'm not making this up. This is this guy's story. And to kind of act as though we shouldn't care about the predicament he's in because he has a criminal case and we are in a rush to set stuff for trial. It's a little,
Well,
I don't know.
I think the rush
Unempathetic,
is
is that the
over
right
now.
word? What's
I think
that?
the rush to set things for trial is over now. There's only one other judge we have that has to get COVID, and there will be no rush to have trials.
I don't know, Ray. You're gonna love
We've already had part of the equation taken care of.
When you show up in Woodstock, which I shouldn't have to say because it's the only place you have to go right now. But when you go to court in Woodstock, in courtroom 302, one of the felony courtrooms, there is a 80-inch monitor that has 10 months of calendar up with color-coded days to tell you whether or not those days are overloaded or whether or not they're open or whether or not they're close to being overloaded. It's like the pie charts are living on a calendar now. So we can all look at that calendar and say, "Ooh, this is a good day," or "Ooh, that's a bad day." So
Hey, that's how the Terminator saga began. Okay. The pie charts are coming to life. They've always been in the background making our lives miserable. And it's, one person constructing the pie charts. But now the pie charts are coming to life. Now we have to see them. Now we have to answer in person live to the pie charts. How long before the pie charts are going to have a third podium next to us in front of the judge?
Well, it's like the calendar is there to show us that this wasn't just something they were saying. This is real stuff. We've got color-coded calendars, people. This is legit. Like,
pie chart will be granted full party status.
You guys are negative about this. I am positive.
No, Ray, I'm so for it. I look at the calendar and I see there's a year of challenge right there. Ooh, yellow date. Judge, I need the yellow date. No, Judge, I need the yellow date, Judge. I gotta have the yellow date. Oh,
No. Okay, hold on. All kidding aside, rewind to the Monday after a Monday holiday.
Oh, right.
When in effect, we would have a double call because nobody knew that there was a Monday holiday. It really crept up as a surprise. So as a result, all the cases that would have been on that Monday, of course, went to the next Monday.
Yeah.
Causing a 70-page call that would be completed sometime in the afternoon.
It has to be a Monday because God forbid we take some Monday cases and put them on Wednesday or a Thursday or some other day.
Animals? We're just living in a state of anarchy?
Matt,
what are we, animals?
Matt, there are prosecutors that are assigned to those days.
It's I wish at least, I mean, we're mocking McHenry for good reason. And part of the reason I think we all make a good bit of money in McHenry is because somebody comes up from DuPage County, looks at a calendar and says, Judge, I'm open. It's Tuesday. I understand that, but I'm open 4 Thursdays from now to come back out here. And they say, oh no, this very serious traffic case where nobody's going to go to jail and your client has to take off work has to be on a Tuesday. And other places aren't that beholden to calendars on such a wider range of cases. But
and I'm not going to besmirch the entire McHenry County court system. The pie chart has one baker. One man's making that pie chart. And it won't be long.
You want to tell us something about him?
I don't think it's going to be long before the pie chart is granted full party status. It has a say in the outcome of a case. If we want to we have to talk to the state. The state has to talk to the victim, and then we have to have a 402 meeting with the judge, the state.
To be fair, Pat, and shifting the discussion just a little bit, the pie charts are about scheduling right now. What is going to happen when they look back at their record and discover that they have a large number of not guilties? Are there going to be a pie chart for guilties and not guilties?
No, Ray, this is like DUI stats for cops. We keep track of arrests. Nothing after that is an indicator of accuracy in any way.
You keep track of arrests.
Yeah,
it's bulletproof. It's bulletproof. They were arrested. Yeah, I did my job.
We don't need to verify those arrests through convictions. We don't need to follow up and say what percentage of these arrests, end up with dispositions on those charges. We've got arrests. We're good. We got a pie chart. The rest of it we're not going to worry about.
When they take
I will say there are many judges who are not beholden to the pie chart like some are. And there are many judges where I can look at them and I can say, I know you hate that goddamn pie chart too. I know you do, because you're here every day and you understand what goes into this, as opposed to somebody sitting in, I won't even say an ivory tower, aluminum sided shed sitting somewhere figuring out the pie chart.
I don't, like 2 examples, like again, this morning, I'm on my way to court for a case that's set for trial next week and I get discovery from the state. Last week, I have a class X trial in another county, in DeKalb County. And between 5 and 9 at night, the day before trial, I received 3 discovery disclosures on a class X felony the night before trial.
They thought you should know that, Pat.
Ray, I got an email that said that. Thought I sent these to you. Thought you should have them. And it's like, one of them disclosed a statement of the victim. One of them was grand jury transcripts, which I wasn't too whatever. And then the other one's part of a police report. And it's just kind of like, well, you've been hanging on to these for 3 years and you dump them on me. And now I'm going to get slack about continuing it, which I did. But how does the pie chart account for that? The late disclosure of information.
For anybody who may or may not be watching, right now there's nobody watching. When we say pie chart, each courtroom gets a chart saying how old cases are and how they need to be moving these cases, regardless of circumstances, regardless of situations, regardless of the fact that, perhaps we've lost a year due to a pandemic, regardless of any reason. This case is this old. You have this many cases in this age group and you have to move them. And I'm not a huge fan. I don't know if I've conveyed that or not, but I'm not a huge fan of it. So that's what we're talking about. The pie chart don't care about late discovery. Pie chart cares about trials. Pie chart cares about when a case is over. That's all it
Pie
cares
chart
about.
don't care.
Nope.
You know what would fix those pie charts pretty quick?
Shredder.
Speedy trial rights.
Stop it.
Let me ask you
Have
guys
any
a
of you
question.
had any speedy trial stuff in 302 where you've made a constitutional
No,
argument?
if you look at the constitutional law, we're not there yet. We're not there. And you would have had to have somebody who either refused to set your case for trial that you've already answered ready on. But just asking you guys, generally speaking, if they institute the speedy trial right tomorrow, what percentage of your cases would you be demanding on and setting?
Our amps go to 11.
You want
Our amps go to 11. I would set 11.
It would
out of
be
10.
back to the early 2000s glory days when I was upstairs in the jury room. It's like, oh, I just got appointed first court date. Give me a trial date.
Yeah. And I can't imagine that right ever coming back.
No, I don't. I think when it comes back, it's going to come back crippled and hampered with all kinds of qualifications on it.
100%. 100%. It will be a shell of what it once was.
So I don't know. I talked to Pat about this, Ray. I don't know if you saw that link I sent.
If the trials start to fade toward a administrative law treatment.
And this was something we touched on, as far as administrative courts, and we're seeing more of it out here. You guys kind of thought that that's what we were headed more towards. And my experience today was I went, and it's not something we don't do a ton of administrative law, because administrative courts, at least in these parts, are overseen by a judge.
I was devastated one time going to administrative law court.
It was I don't know, what is it, what kind of training? Was it probably an 80-hour course or something to be an ad law judge?
I don't know that it's that long.
I don't think you have to be any kind of real judge to do that. I think in theory they can let the chief of police do it.
Right.
Well, okay, then it certainly makes more sense, because I had one today where, for those of you who aren't familiar with this, don't do what we do. When I say a lot, all of the towns around here have a $500 impound fee. You get arrested for DUI or license suspended or revoked. They tow your car. You have to go pay. It's an impound fee. It's not a penalty. It's not a fine. Okay. You have to pay the village or city $500 to have the privilege to go and pay a tow company $200 plus whatever the storage fees are.
Right.
My guy gets arrested for DUI on, we'll say the 12th, the 11th. He gets arrested on the 11th. There was an accident. The car's crumpled. Calls his insurance company. The insurance company comes out, goes and gets the car from the tow yard. 9 days later, the lien holder and my client get a letter saying, oh, your car's impounded. You have to pay this fee if you want it back. Car's gone. The insurance company took it because it was totaled. So I went and they set it for hearing today. They said the police officer was going to be here. Great. Free deposition. Then they said, well, we're just going to go on reports because it's administrative court and there is no evidentiary standard whatsoever. So they go on reports. He's starting to argue probable cause. I said that's not really my point, but go ahead. And I explained to the judge, because it seemed like he didn't know, and I was correct in my assessment. This is essentially a forfeiture. If they forfeit your car, they're forfeiting your car. To get it back, you pay the forfeiture fee and they waive their right to forfeit it. You have a choice. If my car's worth $316, keep the car, here you go. It's a choice. It's a forfeiture. When you forfeit property, you have a right to either contest it or not. I tried to explain to the judge that they waived it. He was very confused. I said, you can't come back later after you give somebody their property and say, oh, by the way, you owe me for doing what I forgot to do in the first place,
Right.
and not giving you the choice on whether or not you need to pay it. Fairly simple. Prosecutor then came back and said, well, there's probable cause, and recited the facts of probable cause again. The administrative law judge then looks at me and goes, whoa, 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 whoa. How did he get this car out? And I explained to him again, there was no notice of forfeiture. There was no impound fee. There was no notice given until 9 days after the accident. Nobody did anything wrong except the police. They didn't enforce their random penalties properly. So you can't come back after you didn't give them the choice to let them keep the car or not and say, you took the car, give me the $500. Because my guy didn't even take it.
Right.
So how long did it take you to lose?
Well, it took me 30 days. It took me 30 days because here's why, Ray. The administrative law judge looked me straight in the face and said, I'm continuing this for 30 days. And it reminded him that they've answered ready for hearing twice, didn't have the cop here like they said they were, and wanted to go on reports. And he looked at me and said, yeah, but I can't find by a preponderance of the evidence with the evidence they've given me here.
Well,
Yeah. How did you like that?
And I looked at him and I kind of, Matt and Ray have both seen the Pat Walsh pen flip. He got about a 7 foot in the air pen flip. And he said, is there a problem? Do you have a response? And I said, I'm going to let that hang out in the air there for a second, Judge, to maybe you realize what you just said. You're continuing it because you can't find against me, and you're giving them more time to do what they weren't able to do on the day of the hearing. And even when I put it that way, he said, yeah, I don't know what happened here. I said, well, because they don't have the horses. He goes, well, quite frankly, you don't have the horses either. And I said, well, it's great. It's great because I don't have a burden that requires
Right.
horses.
Exactly.
And he repeated it. Well, I can't make a finding in their behalf today, so we're going to continue this. Now, this is somebody who was a prosecutor, has done some defense work.
Listen.
You know who it is.
No, I appeared in front of this guy last fall. And after the hearing where they went on reports only, the prosecutor reading what the allegations were, he's about to make a finding for them. I have put on my client has said he has refuted. I says, you've refuted all those things. And he's going to fine for the city. And I was like, oh no, no. And if he hadn't sensed that it was going to be Tropical Storm Flavin. Well, no, it was like, I was like this. I was like, there's nothing left for you to do. You have ruled enough. The case is, we're done. And he goes, well, they made a lot of good points, and I'm like, them making good points isn't the point. If they carry their burden, they win. If they don't carry their burden, they lose. And as I said, it was almost demeaning how bad it was. So I can hardly wait till they add that to regular court.
Well,
So-
this guy's the only guy I've ever actually sworn at on the record in any kind of judge capacity. And there may be transcripts out there with a random voice dropping some 4-letter words that
Somebody else's voice, of course, right, Pat?
other colon. God damn it. But yeah, it's scary. It's scary, and it flies under the radar screen because
Well,
it's just a city collecting
it's
money.
also demoralizing because you get these rulings that are just incredulous. You're like, what just happened? And they act like, well, that's of course what happens. That's what this hearing is for. And you're like, what?
So
What?
I don't want to derail this chat and actually talk about law. So I'm just going to interject this and we get back to the ranting because this is the part I like. But Pat, I just emailed you a case. These seizures have kind of been an issue of mine that have been festering out there. When I have time here and there, I kind of look at them, and there are some pretty slick lawyers downstate who have filed class action lawsuits against some of the municipalities based on, and Ray, here's the part you're going to love, whether or not these seizures are fees or fines. Because as we know, if they're fines, it triggers potentially Eighth Amendment. It triggers a bunch of other stuff. So Pat, I did just email you a case which is not directly on point with what you were talking about, but may give you some ideas. And at some point, if you want to get together and talk about things, I got some thoughts on how to deal with this stuff. The reality is that this whole system is set up to cash in checks because people aren't contesting it. They make it quick, they make it easy. And like I think Pat said a couple of weeks ago, something about the most coercive device they have in the system is making people skip work over and over again to come to court. You've got somebody who's missing a day of work. Even let's say somebody making $10 an hour. Am I going to skip a $10 an hour day of work to go get a car that I'm probably, or to go try to save money I'm probably not getting back anyways? At that point, I'm just throwing bad money after good, right? So by and large, people don't show up to contest these, and this system is not tested at all.
And that's one of the arguments I made today. I said, if it's just a question of, well, if he's arrested, he shall, that's a fine. That's a penalty. That's not a fee. That's not an optional fee. If you want to do it. There's towns out here that make, they pass the ordinance, they adopt the vehicle code and then say, well, this is our minimum fine. That's how you do it. That's included in a DUI guilty plea or conviction or supervision will be a fee of boom. That's how you do it. You don't do it this way. And I just looked at it. I want to make sure you're sending it to my right email address, but
It was P.
Yeah,
Walsh, I think it was your business address.
P. Walsh at Donahue and that
Is it
one?
P or is it P dot?
P. No dot. That dot one disappeared into the ether.
P. Walsh at Donahue Walsh?
Mhm.
So I'll send it today. It's not right on point with what you were arguing, but if you're getting more into the business of appearing on those, and I'm hoping to as well, this is something that, you should keep an eye on. It's basically a civil judgment that was overturned, but it should, I actually got tipped off to this through one of the local prosecutors, kind of. It's a long story. Pat, it keeps coming back to me. I got your personal email. I'll shoot it there if that works.
Okay.
But I kind of backhandedly got tipped off to this kind of through one of the local prosecutors. So I would imagine some of the villages should kind of be prepared for offshoots of this. But
if there's somebody suing, I'll more than happy refer a whole bunch of clients to them.
yeah, and to me, so what's interesting to me is that on the civil side, which let's be honest, we don't like going there. But on the civil side, you would be able to deal with the system very easily through a class action lawsuit. But as Ray can tell you, when you try to bring a class action lawsuit against the government, they've either given themselves immunity or made it hard for you to do it, or they're claiming this has to be dealt with in criminal court. So I think the only reason the system even still exists is just because they have found the sweet spot in taking advantage of people and stacking the odds so much against them that it's just not worth their time to show up.
Well, and plus, in addition to not liking the civil side, it's clearly more dangerous over there. They don't have anybody on that side. We're on the safe side. We can bring people to the criminal side. We can stack them like cordwood by us. That's. Remember the old Planet of the Apes, the Forbidden Zone? You couldn't go over there because it was dangerous. That's the civil side. That Corona must be going crazy over there.
They got their own little bubble over there. And if
Yeah,
we were making hundreds of people show up for status dates every day, the terrorists have won.
Well, speaking of back to normal, when are we getting back to normal, boys? It's about 51 weeks since our predictions were made. I think I started joining you guys like at maybe about a week or so into it. We're just about there. This is the longest 14 days to flatten the curve I've ever even thought of. Remember that 14 days, we're going to flatten that curve.
It was a Scaramucci, right? That's all it was going to be.
Oh my
One
God.
Scaramucci and this thing is going to be out. For some reason, New Zealand, which of course I'm only paying attention because of the America's Cup, New Zealand has an outbreak. They clamp everybody down for like a week and then they just open back up, and it seemed to work pretty good for them.
There were months where they had 0 cases over there.
Yeah, so whatever they've been doing seemed to work, and they weren't locked up. I don't know, but the whole thing's a mess, man. I'm ready to get out of the damn house. So,
But well, I mean, Texas and Mississippi should get it squared away for us.
I don't even know what to say about all that. So Ray, I want to going back to Russian stuff for trial. I'm going to give you, I talked to Pat a little bit about this. I'll give you the background. I was on Zoom. I decided to drop it on Zoom at 26 in California or YouTube to just kind of watch what was going on. It was the day that one of the Jussie Smollett things was going to be there, because whatever, that's not important. And I'm watching this judge and I'm hearing things like the public defender saying, hey judge, our last date was arraignment. This is our first date after arraignment. I'd like one more court date before you force me to set this for trial. And these are attorneys begging for basically a 60-day date after arraignment before they're forced to go to trial in a case that they didn't investigate, that they didn't get to choose when it got charged, that they probably don't have full discovery on. And I was watching it thinking, wow, this is a lot different than anywhere I practice, and this makes me very happy I got rid of my Chicago office, because this is just not the way this is supposed to work. So I Googled this guy's name, and that's the link I sent you guys, and we can talk about this. Did you read this link I sent you, Ray?
Not
Look
yet,
at
no.
that. Pat, why don't you tell Ray what you read?
Ray, I forget the judge's name.
Lynn, I think it's Judge Lynn, Linn.
Yeah, he what was it years and years and years and years ago. He was presiding over a bench trial. It was a sex case. The penalty for whatever he was charged with was natural life. Jury found him guilty. He did a judgment notwithstanding the verdict and found this guy guilty of a lesser charge that was, I think it was 18, right?
Yeah, still hits him with 18.
The guy's going for 18 years. It's not like he's walking out. And it upset the state's attorney, and I think it was Ms. Alvarez at the time. There was an email from Ms. Alvarez.
And I just want to point out, if you look, this is the Better Government Association webpage that mostly prints public salaries. I don't know if I'd call them a watchdog. They're kind of a, government information conduit, whatever. So
Says watchdog right there on the title.
There you go. But this is not, the New York Post or the Chicago Sun-Times or somebody. Go ahead, Pat.
So finds him guilty of a lesser included, notwithstanding the verdict. It does not make the State's attorney very happy. Matt can scroll down to the emails. We can read them exactly what she says. Long and short of it is they start SOJing him. In theory, these cases are randomly assigned. What's his problem? Anita Alvarez says. This is getting out of hand with him. Apparently he had some verdicts and some decisions that were not favorable to the state, and God forbid a defense.
Look at this email. It starts with Judge Lynn and his aversion to natural life sentences appear to have struck again. Like, who is this guy thinking people shouldn't be caged up for their entire lives? I'm sorry, go ahead.
And really on the defense new motion, the defendant was facing a natural life. ASA Miller tried the jury. Rather than proceeding to sentencing, we ordered the transcript and took a short date to May 2nd to determine whether there's any action to take. Mary Boland from appeals looking at the issue. So they started SOJing him four times more than the state's attorney SOJs anybody. After that occurred, Ray, as we can see in the highlight, it's never been fully explained, but the number of felony sex cases randomly assigned by computer, sharply decreased in following years, suggesting that court officials aware of the state's attorney's campaign largely stopped assigning sex cases to
How
men.
did the random computer figure that out? Is this AI, Pat?
This is the pie charts coming to life, Ray.
It all comes full circle. The computers are running the show and they are not happy.
So this isn't just, prosecutors from the bench helping out the state. This is the court administrator, Stray Shun. This is, Hal, the computer in Cook County, saying, okay, well, the state's attorney's not happy with this guy. We'll just stop giving him cases.
So Pat, what's our remedy for that?
I don't know, because I've never seen anything that blatant. I mean, I think you'd have to figure out what the odds are of your case landing in front of Judge Lynn, and you'd have to, but I think if you could just show, if you had enough evidence here, if you were one of the guys that was convicted during this time, I think you would have a lawsuit there. You'd have a civil rights lawsuit pretty.
Yeah, but you're gonna.
dried.
I think I disagree, because I think that you're stuck, and you're stuck because they're going to say this. You have the right to have a judge who will determine your case fairly. However, you don't have a right to have a judge who will determine your case one way or the other or in your favor.
Correct. But you also have a right to not have your case steered to a judge favorable prosecutor.
It's like this. Yeah, but I think it's what Matt said. Then what is the remedy? Because the remedy is not dismiss the case.
I know what the remedy is.
Remedy's new trial.
You don't have a remedy. There's no look.
You have
If
no
they're
remedy.
intentionally, and let's be honest, they write this article up like, wow, we can't believe the computer just started doing this. But the reality is that computer spits out a name, somebody is sitting there, and there have been other times that this exact problem
Best journalist ever, by the way.
There's somebody
Right.
who's sitting there going, oh, the state's just going to burn a substitution on Judge Lynn. Let's not bother doing that, right? Let's send it off. I don't know that you have a right. I don't know that you have a right to do that. In theory, couldn't Cook County just say we are reorganizing our structure and we're not doing any sex cases in that room. We're moving them all to room whatever. Like, we could make that room the sex case room, right?
The thing
Yes,
is,
but then it's regular.
is
It's not somebody randomly assigning your case to a favorable judge. Then you know where it's going to go. This isn't. It can't be part random and part, mandatory.
So Pat, explain to, I don't know if anybody's watching, but explain. Look, the way an SOJ works, there's substitution of judges. Every side gets at least one in a felony. You get two on a class X or something bigger. And
That's what I disagree with. The state should not get a substitution.
Well,
It's
so that's
it's all their system.
So Pat and Ray, why don't you explain, if the state would just be substituting him anyways, why do we care?
Well, theoretically, in Cook County, according to this system, the way it was set up, it's going to be randomly assigned to somebody else. Perhaps if this is a one SOJ level case, if it's not a capital case, if it's a one SOJ case, maybe if the randomness is actually random, maybe you land in another judge that's not, 100% pro-state. Make them use their SOJ. If they have it, make them use it. And I'm with Ray 100%. The state doesn't have a right to a fair trial. The state doesn't have a right to a speedy trial. The state shouldn't have a right to an SOJ. There's nothing in that piece of paper guaranteeing the rights of the state. That piece of paper was drafted to protect citizens from the state, not to ensure any rights of the state, because the state has everything to begin with.
Yeah, but as was explained to me about a month ago, there are some, and I'm trying to be careful here, who wear robes, who apparently are interpreting the 10th Amendment as saying, if that right isn't specific to an individual, there's nothing saying the state can't do it. So I can tell you there are some judges that would take, look, we all know what the statute on speedy says. We all know what the Fourth Amendment says, but the Fourth Amendment says the state doesn't, it's silent on it. So in theory, it doesn't say the state doesn't have those rights. Do you know what I'm saying?
Yeah.
I mean, I'm with you guys, but I'm telling you that it is getting it for whatever reason. That's the interpretation some of these judges take.
I hear that phrase a dozen times a week. Well, the state has a right to a trial too. Really? Please show me where.
I remember, it's funny you say that. I remember a judge who's long since retired, moving into a courtroom when I was at the public defender's office that I'd been in for some time and knew the runnings of pretty quick. And the phrase, I'd never heard anybody spin the phrase justice delayed is justice denied to mean that states' requests to try a case should be met with trying that case as soon as possible. I'd always interpreted that phrase to mean, somebody who's injured or a citizen who's got a Fourth Amendment violation but has to sit in jail for 6 years before it gets heard is not really getting justice at that point because they've already been punished. But apparently there's judges out there spinning that to mean that if the state doesn't get their way in their terms, that their justice has been denied too. But the scary thing to me about this is it's like we're fighting a paper battle. We've got a Fourth Amendment that says here's our right. We've got a Fifth Amendment that says here's our right. You, Ray, me, everybody who does this, we pick up police reports, we look at these documents. 90% of the coercion or pressure in this system is done through informal stuff like this, like requiring people to take off work every 4 weeks for no reason. Like assigning cases away from a judge the state doesn't like. And I don't want to name names, but we can all right here, and I can talk to you guys about this in at least 3 different counties, name a judge who's no longer sitting in criminal court because prosecutors complained about it.
Right.
Yeah.
It happens in every county. I mean, Boone County, which only had, I think, 1 felony judge at one point, the state started SOJing him on every case. So how did the circuit respond? They moved him to Rockford and they sent somebody in the state with an SOJ. And what did that guy do? He spent 20 years sending people to prison. So there's a subtle manipulation of the system that doesn't show up in sentencing orders and it doesn't show up in discovery, but it has a huge effect on the system. And looking at this, you guys know whether or not we want to exercise a substitution of judge motion is a huge deal. Like that's not a joke. It's something you think about and to basically put the state in a position where they don't have to use an SOJ and then right off the bat put you on your heels where you might have to do an SOJ to get it possibly back to somebody you think is fair is putting you at another disadvantage that's not going to show up anywhere on paper. And I'm with whoever you said, whoever came up and did the research on this. I mean, this was like really good work because it kind of exposes a pretty dark and dirty side that happens, I think, in every county and has a profound effect on the entire system.
I've filed SOJs every here and there, and I've gone to the court administration, and I've heard them joking about who they were going to send the judge to, and see how, not knowing I was there waiting. He should like that. Let's send it here. Like he's exercising his statutory right. Let's really piss him off. I've heard it.
No, it's as I said, Aaron, as Matt said, the problem is that I don't think that we always talk about these things in terms of the system. The problem is that I think there's just these giant problems with the system and they don't get cured. That's the problem.
Ray, they don't get cured because you know what the response to this is going to be, which is if people had a problem with this, why didn't they say something years ago? And the reality is that it's been hidden and it's been buried. It's the same thing, Ray, like when we sued them over the court costs. Well, nobody ever complained about the court costs. Well, you've got a coercive system that for somebody to stand up and complain about this would have meant to undo the bargain they just got, and they shouldn't have to be in that position to start. So,
Well, and it goes back to, we joking, but not joking about, how much input when these criminal justice reforms and the bail reform, but how much do they ask for input from the defense bar? Well, the same thing goes with, whoever's managing and administering these systems. How much input do they have from, the people who actually pay the price, who actually suffer from their, let's send it to this guy, see how he likes that. How much input do they have from us as far as creating the system? Maybe
they would tell you that they have the exact correct amount.
So
yes.
Can I tell you guys a little something that maybe I should or shouldn't share?
Please do.
Apparently, let's talk about the criminal justice reform bill, which we've talked about, that a lot of defense attorneys off the record are saying they don't love, mostly because it takes away the bond turnovers, that I have some other issues with. But I talked to somebody who I'm sure would be happy to come in here and talk to us, but I talked to somebody who was on the Illinois State Bar Association criminal whatever committee that bill went to to give it the yes or no. And apparently that bill showed up at the committee 700 pages, 20 hours before they were about to vote on it. And it sounds like one person kind of rushed through it really quick. The entire committee didn't really read it, didn't get a chance to read it. The one person who read it quick was kind of like, yeah, fine, looks good, whatever, and sent it down there with a recommendation, which apparently was controversial when it happened. So it's nice.
How did that bill get past Madigan?
Well, Madigan, this was going on when Madigan was not Speaker of the House, number one, if you recall.
Right.
Madigan was running for Speaker and then got unspeakered, and there was a pause there, and we didn't have a Speaker. But it was the last day of the legislative session. I mean, look, love that bill or don't love that bill, everything about the passage of that bill is dirty, 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 dirty.
Well,
I mean,
especially when they're incapable for 10 and a half months or 9.5 months of assembling and doing anything to show the emperor he's wearing no clothes. That they knocked out 700 pages in 18 hours, 20 hours.
They were saving it.
Yeah. I actually thought Madigan was going to use that bill. He was going to hold that bill up to get his speakership endorsed by everybody who was wanting to push it through. And some of the groups that were pushing it through, I don't know that, well, I know that they didn't have anybody to break down the analysis of what this no cash bond is going to cost a lot of these people who are going to be out on a no cash bond. GPS, ankle monitor, GPS ankle monitors, alcohol bracelets, all those things that are, $10, $11 a day. That'll be nice and cheap.
I think the alcohol sensing ankle bracelet is up to 17 a day. Probably going to be 22 before too long. And then when you throw on GPS monitoring and all that, you're going to be people who were out on a $300 bond for 2 years before are now going to end up paying $4,500 for the privilege of, not being able to post cash bail. So I don't know. I mean, that it's 2 years before that gets enacted, and it's. I know there already is legislation pending to fix some of it, but this is in general, no matter what side you're on, why laws are not supposed to be made like this, and underscores why. And I know I speak for Ray because I heard his platform when he ran for state senator or whatever. I don't know if I speak for Pat, but in general, why I think your average criminal defense attorney is just against new laws, period. Because these laws get passed in weird ways. Nobody cares about the unintended consequences. And then it's the little guy on the short end of the stick. And everybody goes, well, we didn't think of that, but we're not going to change it at this point. So,
Right. How many of these people are going to, released on no cash bond? Well, you haven't paid your ankle monitor fee in 30 days. So we're going to revoke your bond.
So I can tell you in counties, not McHenry, because McHenry's doing it different, but the ankle bracelet thing by some of the judges, and judges deal with it differently. Some of the judges will not get into owing money on that. Like, they won't hang cases up. They're like, that's a civil thing. It's between you guys. So some of those judges kind of look at that as a not my problem thing, but over time, all of that is going to get sucked into the state, into probation, into the sheriff, into pretrial release, into all that. And we know exactly where that money is going to end up going, and it's not going to be back to a private corporation somewhere.
Well, it's going to be another pie chart. In addition to having cases outstanding and rotting on the vine, your courtroom is way down in collections on your bond conditions.
Pat, where do we go when the amount of money per day the state makes on somebody on bond keeps going up versus the desire to keep the pie charts in check by closing cases early? What wins at that point? Like, if the government is actually going to make $15 per day somebody's on bond, do you think that will trump the incentive to move cases quickly? Because I think all of a sudden cases are going to linger for 8 years.
I think the timing pie chart then succumbs to Terminator 2.
Do the charts fight? Is that what happens at that point?
It's the unstoppable force.
No, it's the chart versus it's the chart versus the balance sheet. They're like, we're making $4,500 a year on these services.
Yeah.
If it takes 3 years, we're making 13.5.
Yeah. So I would think there would be a happy medium leaning towards the non-punitive, non-cash bond, cash cow that's going to be created out of this.
Can you see why I'm a little bit cynical about the future of the law?
I don't know if we're just becoming crabby old men or it's really as bad as we think.
The thing is, I'm not crabby about it. It always appeared to me to be a little bit wrecked, and it was never improving. And it wasn't like, I'm not one of those people who is like waiting for Jesus to come back. There's going to be this catastrophe. I'm not predicting catastrophe. I'm predicting it just literally never improves.
Do you know what is a phenomenon I guess just kind of become aware of? I did another trial this week somewhere else with a fresh attorney. And I think this is going to feed into the idea that the way things were before is going to get changed. It's going to be like less towards litigation and more towards money sucking. Is we have a year of institutional experience that has been lost to the new generation of lawyers. If you got barred a year ago and our prosecutor or public defender, in the old days, you might have done 100 trials already or 50 trials. Now you've probably done 4. And I'm only thinking of this because I did a trial Monday that led me to think maybe I was a little more experienced than the other person. But you've got kind of a generation, and if we're going to just trickle the trials back, we're not just going to start them back up. You're going to have people who are working at these jobs that normally would get a ton of experience that don't, going on years. And those people aren't going to turn around and go, all right, let's turn around like a faucet. Let's get ready to roll. In 2 to 3 years, you could have people who are it's already happening, but moving into low-level felony positions with very, very few trials under their belt. Or you could have state attorney's offices that have a whole bunch of new people with no experience and not really anywhere to put them. And I think that feeds into like what Ray's saying, because you're going to have those people coming up now aren't going to be saying, well, we need to like flip a switch and get this back to where it is. They're going to say, well, we've been getting along fine without doing this stuff. Rather than have this charade of maybe someday we're going to have a trial, why don't we figure out a way to extract money out of these people quickly and call it a day?
Yeah. Yeah, I mean, we're seeing more and more younger and younger and younger, and like some of them seem like they just started shaving.
It
Prosecutors coming in.
isn't that they're younger, Pat. You're older.
Oh, Ray, I can't wait for you to come back. I
I
can't.
already heard. I already heard.
No, okay,
We have like a 14-year-old in 203.
Ray. Some of the ones that were here when you left, that's
Yeah.
Pat Walsh getting older. Some of the new ones, they're young.
Okay.
Like I would guarantee you, probably half the shirts in your closet older than them, young. I know half the shirts in my closets are older than them.
Yeah. Wow.
But you know what? At least not in Woodstock. Most of those young people, they're all right on Zoom, which is better than, some of these Zoom courts you log in and it's like a 70-year-old judge with a 60-year-old clerk and somebody who has, learned the internet when they were in their 50s, and you're just like, ooh.
It's me. I'm not a cat. I'm here. I'm ready.
I'm not a cat.
I'm not a cat. Oh, I miss that guy.
What topic would you like to wrap all this up with, guys?
What's here, Matt? Take the screen down here. Hold on 1 second.
Oh, sorry.
All right, are we done?
We're not done yet. We have been paid for an additional 5 minutes.
Okay.
I'm on no time. I'm on no time constraints. You guys can talk. I'm able to talk about whatever you want to talk about.
Well,
One
the thing is that we've had no contact tracing at the courthouse, and now the courthouse is closing. Or is it closing? Or is it closing?
It's not closing. It's not closing.
Okay. The staff has been infected with COVID, unlike the time that the state's attorney's office was infected. But when we said it was infected, they said it wasn't, even though it was.
Ray, I just want to say that you are speculating because there's no formal announcement, which I'm sure is due to HIPAA. So these rumors of half the courthouse having COVID are at this point unsubstantiated rumors. They might just have allergies.
We were supposed to, the Department of Public Health, when people said, hey, I was in court, where were you? I was in court. Okay. The courthouse was supposed to notify us. And on 2 separate occasions, we had attorneys with people that day who tested positive. Just by circumstance, these people also had a civil lawyer or a family lawyer. The civil lawyer, who hadn't seen them in over 30 days, got a call, hey, your client was in court today. They were infected. The only way my firm found out that our clients that we were with that day tested positive that day was the civil lawyer contacted us. The courthouse, who was supposed to let everybody know and do contact tracing and all that stuff, not one time did they ever call my firm. Not one time. The civil lawyer who got the call, who hadn't seen either one of those 2 clients in a month.
Did anybody get a call when the judge did or did not get COVID?
No.
So are you talking about the most recent judge?
Yes.
So I'm walking out of there today, and the public defender's like, hey, did you hear the judge has COVID? And I said, yes, of course I heard. They called me right away because they know I'd been in here the last 2 weeks and been possibly exposed, and they wanted to let me know. And he looked at me and he went, really? They didn't call me? I'm like, how long have you known me that you fall for that? Like, that tells me a lot about you.
Poor trusting soul.
Poor guy.
Poor guy. He's sure he's got a future in something, but I don't know.
Okay. Well,
boys, hold on 1 second here.
he's got something. I can see. I
would
can
like
see
to
the
wrap up.
screen.
I would like to wrap up today
Oh,
with a shout out and a thank you so much for everything she did to one Lady Margaret Thatcher Walsh. God rest her soul.
Aw.
she's a beautiful girl, Pat.
Aw.
We lost her a week ago Monday.
Oh,
Tuesday.
that is too bad. Oh, that's
Yeah.
what a puppy.
The
What
prettiest
a
princess,
puppy.
the most beautiful bulldog, the baddest boss bitch ever. She was the perfect dog at the perfect time for the Walsh boys and Ma Walsh, and she will always be missed. She was amazing, and we love her and miss her. So, rest in peace, Lady Margaret. She was the best.
You were lucky to have her.
Yes, we really
She
were.
looked- She
She
looked
was
good.
awesome.
On that somber note, gentlemen, have a good
Boys.
night.
Adios.
And I think Matt is frozen, and I think that's probably appropriate.
No, I'm here. I'm here. I'm definitely here.
Oh, you were reading. Okay.
Yeah.